Welcome, fellow knowledge seekers, to another deep dive. We often imagine the world of law as, well, stoic, rule-bound, maybe even a little dry sometimes.
Mm-hmm. Predictable almost.
Exactly, but sometimes, when the stakes are incredibly high, like when a child's entire future is hanging in the balance, the courtroom becomes something else entirely. It turns into this stage for intensely human drama.
Absolutely. It forces you to look really closely at the people involved, their motivations, the pressures they're under. It's fascinating and sometimes quite confronting.
And today, we're plunging into exactly that kind of story, a real-life legal saga from Australia. It's a case that started with a child in real danger and ended up putting a prominent barrister's, well, his whole career under the microscope.
That's right. And this isn't just about one court case. It's really a cautionary tale. It's woven right into the fabric of legal ethics. We're
Wow.
talking about Alexander Stanislaw Howen, a Sydney barrister,
Right.
and how his conduct, his actions in a really fierce courtroom battle over a child's welfare led him step by step all the way to a disciplinary tribunal. It became, a really stark lesson for lawyers everywhere about the incredibly fine line they have to walk.
So our mission in this deep dive is to try and understand the Hohen case, not just as like a sequence of legal events, but more as a window into the ethical challenges that are just inherent in being a barrister.
hmm Why does it matter? Especially if you're thinking about standing up in court, fighting for someone else.
Exactly. We want to unpack it all. We'll follow the story right from the beginning, that intense original children's court case, then the explosive moments during the appeal that actually triggered the ethics complaint.
Then the tribunal hearing itself, which was high stakes, obviously.
Yeah.
And finally, the complex, kind of surprising, and, well, ultimately quite tragic legacy of Hohen's actions.
And we're drawing our insights from some really compelling source material today. We've got excerpts from a legal true crime podcast script that helps set the scene, gives it that dramatic feel.
Yeah, and crucially, we also have the detailed, very meticulous judgment from the disciplinary tribunal itself. That document really lays bare the arguments, the evidence, and importantly, the ethical reasoning at the heart of the case against Hohen.
Okay, so let's step back. Where does this story actually begin?
It kicks off in 1999, Sydney, Australia, and right at the center of everything is a baby girl. The sources all refer to her using the pseudonym Victoria, obviously to protect her identity.
And her early life was difficult.
Tragically so. Victoria's first few months were marked by serious harm. Within a really short period after she was born, she suffered 5 significant injuries.
5.
5. Some of these happened while the family was in India before they moved to Australia. Then 2 more occurred after they arrived in Sydney. And these weren't minor things. We're talking severe injuries, including serious head trauma, which unfortunately led to developmental delays for her.
Injuries like that, especially multiple injuries in an infant, that's going to raise serious concerns.
Absolutely, and it did. By October 1999, the Department of Community Services in New South Wales, the Child Welfare Agency, known back then as DOCS, they stepped in. Their alarm bells were definitely ringing. They suspected abuse.
So what did they do?
DOCS initiated legal proceedings. They went straight to the Children's Court, seeking what's called a care order under the relevant law at the time, the Children Care and Protection Act, 1987. Their goal was pretty straightforward: protect Victoria. They believed she was a child in need of care because of the injuries and the perceived risk of future abuse.
And the court's immediate reaction.
The first step was an interim measure. On November 4th, 1999, the court placed Victoria with foster carers. This was, a temporary thing just to ensure her safety while the court began the long process of figuring out what was best for her long term.
Okay, so the foster care placement happens, and that's when the legal battle really starts.
Exactly. The battle lines are drawn. And these court proceedings, you have to remember, were incredibly sensitive. They were held in a closed court, no public allowed. Everyone involved, Victoria, her parents, they all used pseudonyms to maintain strict confidentiality.
So not a public spectacle at all.
No, not at all. This was a very private fight, but with incredibly high stakes for everyone involved.
And the parents, they obviously opposed DOCS.
Naturally. The parents, an Indian-Australian couple referred to as Mr. X and Mrs. X, they opposed the care order. They wanted their daughter back. And this is where Alexander Stanislaw Howen, the central figure of our deep dive, actually enters the story.
He was their lawyer.
He was engaged as the barrister initially to represent both parents in the children's court.
Both. Okay.
Yeah. And Victoria, as is pretty standard in these cases, she also had her own separate legal representation. That's to make sure her specific interests were independently put before the court.
Right. Makes sense. So how did this case play out in the children's court? Was it quick?
Far from it. The case was heard before Deputy Chief Magistrate Syme. She's referred to as Magistrate Syme in the sources. And the trial was, well, protracted, is putting it mildly. It spanned an astonishing 40 days of hearings.
40 days. Wow.
40 days, spread out over quite a significant period, too, from May 2000 all the way through to February 2002. Just imagine that, 40 days in court on one case.
The evidence presented must have been incredibly difficult. Harrowing, the sources say.
Absolutely. Details of Victoria's injuries, the family dynamics. It would have been extremely tough to hear. And for Howen, the barrister, the challenge right from the start was immense. I mean, how do you defend parents when you're faced with undeniable medical evidence of severe injuries to their child?
What was DOCS's position on who caused the injuries?
Their suspicion fell squarely on the father, Mr. X, as the perpetrator.
Yeah.
And they believed the mother, Mrs. X, had, at the very least, failed to protect Victoria, maybe even actively covered up for her husband.
Okay, so as this long case unfolds, let's get a clearer picture of the key players, the dramatis persona, if you will.
Good idea. So first, obviously, Alexander Howen, the barrister, initially for both parents, later just for the mother. He's the central figure whose conduct eventually comes under scrutiny.
The mother, Mrs. X.
Yes, Mrs. X, desperate to get her daughter back. But as we'll see, the court later had serious questions about her credibility, finding she wasn't always truthful, particularly in protecting her husband.
And Mr. X, the father.
Mr. X, the father, the suspected perpetrator. Interestingly, he actually disappears from the legal picture relatively early on. In September 2000, while the children's court case is still ongoing, he leaves Australia and doesn't return.
He just leaves. So Howen continues, but only for the mother.
Exactly. After Mr. X leaves, Howen represents only Mrs. X. His focus then shifts entirely to defending her fitness as a mother, arguing she could safely care for Victoria despite all the serious questions raised about her past actions and her truthfulness regarding her husband.
Okay, who else is key? DOCS, obviously.
The Department of Community Services, DOCS. They're the ones fighting for the care order. They have their own counsel. Throughout, we'll hear about Mr. Burke representing them later in the appeal. And within DOCS, two individuals become really pivotal in this whole saga.
Who are they?
First, Mrs. Natakuri. She was the senior case officer assigned to Victoria's case. Her conduct becomes a major point of contention later on.
Okay, Miss Curry. And the second?
Mr. Barry Ward. He was a regional director at DOCS, so he oversaw Mrs. Curry. And crucially, he's the person who would later authorize DOCS's decision to appeal the children's court rule.
Got it. And presiding over that marathon 40-day children's court trial.
That was Magistrate Pat O'Shane Syme. Her judgment, which we'll get to, is incredibly detailed, over 100 pages, and becomes absolutely central to the later events, particularly her very strong criticisms of DOCS and Mrs. Curry.
And just looking ahead, the eventual disciplinary case against Howen that's heard by a different body.
Yes, much later. That's the Administrative Decisions Tribunal, the ADT. The panel there consisted of Deputy President Chesterman ADCJ, Judicial Member Roberts QC, and a lay member, R. Fitzgerald. But that's getting ahead of ourselves.
Right. Back to the children's court. Tensions were rising during those 40 days.
Definitely.
Yeah.
Howen, doing his job as a barrister, adopted a pretty robust defense for his clients. He really scrutinized DOCS's actions, their procedures, their investigation. And interestingly, Magistrate Syme herself also started observing issues with DOCS's approach. She noted what she called a hard line being taken by the department, and specifically had concerns about Mrs. Curry's handling of the case.
So even early on, there was this conflict brewing between Howen representing the mother and DOCS, particularly Mrs. Curry.
Yes. That dynamic was established quite early in the piece. And then, as you mentioned, that key turning point. Yeah. September 2000, Mr. X leaves Australia.
Howen's job gets even harder, presumably, defending the mother alone.
It becomes very specific. His task now is to persuade the court that Mrs. X, despite the court's emerging concerns about her past truthfulness regarding her husband, is now capable of putting Victoria's safety absolutely first and is a suitable, safe parent moving forward. A very challenging defense to mount.
Okay, so after this incredibly long process, 40 hearing days spread over nearly 2 years, we finally get to the judgment, July 1st, 2002.
That's the day. Magistrate Syme delivers her decision. And as I mentioned, it was extraordinary in its length alone, over 100 pages. Highly unusual for a children's court matter, which signals just how complex and important everyone considered this case to be.
And the findings themselves, you said they were striking.
They really were. First, Magistrate Syme found quite clearly that Mr. X was responsible for Victoria's horrific injuries. No ambiguity there.
Okay, finding against the father. What about the mother, Mrs. X?
This is where it gets complex. Magistrate Syme made some very strong findings about Mrs. X's credibility. She stated Mrs. X lacked candor. She found she was not necessarily a person of truth, but a person who will say what she believes is going to be in her best interests.
Ouch, that's quite damning.
It is. The magistrate also noted Mrs. X displayed arrogance and was evasive in the witness box. She concluded that this lack of candor stems primarily from Mrs. X's desire to protect Mr. X.
So, serious credibility issues found with the mother, but you mentioned the magistrate also criticized DOCS.
Oh, absolutely. She didn't hold back at all. She directed very strong criticisms at the senior case officer, Nada Khoury. She found a lack of objectivity from Khoury that had permeated these proceedings. She described Khoury's reports as one-sided and showing blatant bias.
Blatant bias, strong words from a magistrate.
Very strong. She even specifically called out a comment Khoury had apparently made about India being a third world country. She found Mrs. Khoury's attitude in court was combative, overly critical, and judgmental towards Mrs. X. She even commented on observing Khoury making facial expressions showing disapproval during the hearing.
Wow. Did the criticism stop with Mrs. Khoury, or did it extend to DOCS as an organization?
It extended to DOCS too. Magistrate Syme found that the department had failed in some of its duties towards the family. She felt they took a hard line, adopted a closed-mind attitude, and hadn't properly investigated alternatives to just placing Victoria in long-term state care, which was what DOCS wanted.
A closed-mind attitude.
Yes, she even went so far as to say that Mrs. X's suspicion that DOCS had its own agenda seemed justified, given the way the department had approached the case.
Okay, let's recap those findings. Father, perpetrator. Mother lacked candor, lied to protect father. DOCS and key officer, biased, failed in duties, closed mind. Given all that, what was the final decision? Where did Victoria end up?
This is the real twist, and it surprised many people at the time. Despite all her serious misgivings about the mother's truthfulness and the finding against the father, Magistrate Syme decided to place Victoria back into Mrs. X's full-time custody until she turned 18.
Wow, really? After finding she lied to protect the actual abuser, that feels counterintuitive.
It does, doesn't it? And it really highlights the incredibly difficult balancing act judges face in these tragic cases, trying to weigh all these complex, often conflicting factors. The magistrate didn't just hand Victoria back, though. She imposed very strict conditions.
Such as?
Mrs. X was placed under DOCS supervision for 1 year. She also had to give formal undertakings, promises to the court to ensure Victoria's safety. And critically, one of those specific undertakings was that the supervising DOCS officer assigned to the case would not be Mrs. Khoury.
A direct consequence of the criticism of Khoury.
Absolutely. A clear reflection of the magistrate's severe concerns about her conduct.
So, for Howen and Mrs. X, this outcome must have felt like a massive victory.
A huge triumph. For Mrs. X, she got her daughter back, which was everything. For Howen, it was a major professional win, successfully navigating an incredibly difficult case with very challenging facts against him.
But for DOCS, a disaster.
A bitter pill, absolutely. They didn't get the outcome they wanted, which was for Victoria to become a ward of the state. And arguably just as painful, if not more so, a senior officer and the department itself were publicly, comprehensively rebuked on the official court record in a very detailed 100-page judgment. Reputational damage was significant.
This judgment, then, really sets the stage for the conflict that escalates from here.
It does. And the sources mentioned an earlier incident during the children's court trial itself back in August 2001 that kind of takes on more meaning in hindsight.
What happened then?
It was an informal mediation meeting. You had Howen, Mrs. X, and DOCS representatives there, including the director, Mr. Barry Ward, and the caseworker, Mrs. Khoury.
Okay.
According to Howen's account later, he used that meeting to directly criticize Mrs. Khoury's handling of the case, saying this to her boss, Mr. Ward.
How did Ward react?
Apparently, Ward exploded.
Yeah.
Howen described him saying something like, "I'm not going to tolerate this," and then storming out of the meeting.
Stormed out.
That was Howen's recollection. And Howen's interpretation of that outburst was that Ward was extremely defensive of Khoury, showed no willingness to compromise, and effectively killed off any chance of settling a case then and there. This incident really planted a seed of suspicion in Howen's mind.
Suspicion about what?
That maybe, just maybe, DOCS was more concerned with protecting its own people and its reputation than necessarily finding the absolute best outcome for the child.
And then comes the stinging judgment on July 1st, 2002. DOCS has concerns about Victoria's safety, sure, but they're also dealing with this major reputational hit. An appeal seemed almost inevitable.
Yes, exactly. DOCS decided they had to challenge Magistrate Syme's decision. Their official, stated motivation was, of course, deep concern about Victoria's safety, given the findings against the mother. But realistically, given the ferocity of the criticisms in the judgment, there was almost certainly also a very strong desire to overturn those findings and, restore their reputation.
What was their first move in challenging the decision? Did they go straight to an appeal?
Their first tactic was interesting. Just days after the judgment, on July 5, 2002, DOCS filed a summons in the Supreme Court of New South Wales.
Not the district court for an appeal?
Not initially. They weren't seeking a full de novo appeal at that point. It's a complete rehearing of all the evidence. Instead, they tried to use the Supreme Court's inherent parens patriae jurisdiction, basically asking the Supreme Court to step in quickly and just quash Magistrate Syme's decision without a full rehearing.
A faster route.
Potentially. They also got temporary orders preventing Victoria from immediately returning to her mother, and Mrs. X was required to surrender her passport, which caused some initial friction.
How did that Supreme Court attempt go?
Justice Palmer heard the case fairly quickly. On July 19, 2002, he ruled that actually the proper way to challenge Magistrate Syme's decision under the new legislation governing child protection was indeed a de novo appeal to the district court. He declined to use the Supreme Court's more drastic quashing power.
So he sent them back to the standard appeal route?
Essentially, yes. He did note his concern that Mrs. X hadn't initially surrendered her passport, though she did comply that same day. He then formally transferred the case to the district court and directed it be given the highest priority listing because of the urgency involving a child.
How did Howen view this initial Supreme Court maneuver by DOCS?
He saw it as further proof supporting his growing suspicion about their motives. He believed their attempt to avoid a full de novo hearing, where all the evidence, including Ms. Curry's criticized conduct, would be aired and retested, showed they were primarily trying to undo the damaging judgment and secure wardship by any means necessary. It just reinforced his idea of a collateral purpose.
Okay, so following the Supreme Court's direction, DOCS then filed the official appeal in the district court.
That's right. They filed the notice of appeal on July 22, 2002. The hearing was fast-tracked and set to start on September 30th. In the meantime, the interim orders keeping Victoria in DOCS's care continued.
Did Mrs. X try to challenge those interim orders?
She did. Her lawyers applied to set aside the stay order, basically asking for Victoria back pending the appeal outcome. That application was heard and dismissed by Judge Rolfe in the district court on August 14, 2002. Interestingly, during that hearing, counsel for DOCS actually made a submission suggesting Mrs. X's application was an attempt to pervert the course of justice.
Seriously, that's a heavy accusation.
It is, though the judge quickly clarified that such an allegation didn't apply to her lawyers, Howen, and the solicitors. But it shows the temperature was already pretty high between the parties, even before the main appeal hearing began.
So the stage is finally set for the district court appeal. A full retrial of the case, de novo. For Mrs. X and Howen, it's round 2 in the fight to keep her daughter. For DOCS, it's a chance to overturn a judgment they felt was dangerous and, frankly, embarrassing.
Exactly. And the way this battle is fought in the district court, particularly Howen's tactics and statements, is what will ultimately lead to the disciplinary action against him.
Which brings us right to the heart of it. The allegations Howen made during that district court appeal and the ethical tightrope he was walking.
Precisely. The hearing kicks off on September 30th, 2002. It's before Acting District Court Judge Hogan.
Howen is there, still representing Mrs. X, who is now his sole client.
Correct. And facing him, representing DOCS, is counsel Mr. Burke, who the sources describe as a vigorous advocate for the department's position. Witnesses are called, including Mr. Barry Ward, the DOCS director, who testifies about why DOCS felt it absolutely had to appeal.
And a key figure is not called.
That's right. Mrs. Nada Khoury, the caseworker so heavily criticized by Magistrate Syme, is conspicuously absent from the witness list. DOCS made the decision not to call her to give evidence in the appeal.
Which Howen must have found significant.
Highly significant, in his view. It fed directly into the suspicion about DOCS's motives that had been building, remember, the mediation blow-up Syme's scathing judgment, the attempt at a quick Supreme Court quashing. Now, during Ward's testimony in the appeal, this suspicion really started to crystallize for Howen.
How so? What happened during Ward's testimony?
Well, Ward presented what, on the surface, sounded like perfectly legitimate reasons for appealing. He talked about the unacceptable risk to Victoria, the catastrophic nature of her injuries, his belief that Magistrate Syme's orders just weren't sufficient to guarantee safety, and the fact that DOCS had received legal advice justifying an appeal. He painted a picture of a department acting solely in the child's best interest.
Standard reasons for appealing a child protection case, you might say.
Yes. But under Howen's cross-examination, that picture started to, well, wobble a bit. Howen noticed that Ward seemed quite reluctant to fully acknowledge just how serious Magistrate Syme's criticisms of Mrs. Curry really were.
He downplayed them.
He did seem to downplay them, yes, despite having obviously read the very long and detailed judgment. Then, a crucial piece of information emerged under Howen's questioning. Ward revealed that after Magistrate Syme's damning judgment, he, Mr. Ward, had actually assigned Mrs. Curry the task of writing the official briefing note about the case for the government minister.
He assigned the heavily criticized caseworker to write the official report about the case she was criticized in.
Precisely. And Howen pushed further and discovered that this briefing note essentially glossed over the court's criticisms of DOCS and Curry, the really harsh findings. They just weren't mentioned to the minister.
That looks bad, like a cover-up.
To Howen, it certainly screamed of an agency trying to manage the fallout, protect its reputation, cover its tracks. And then there was the issue of Curry's absence from the witness box.
Howen raised that with Ward.
He did. He pressed Ward on why Curry wasn't being called, given her central role. Under that pressure, Ward eventually conceded that DOCS had never actually intended to call Miss Curry in the appeal.
Never intended to call her.
That's what Ward admitted. For Howen, this was another major piece of the puzzle. Here's the caseworker at the very heart of the controversy, fiercely criticized by the magistrate, yet DOCS actively chooses to keep her away from having to testify under oath in the appeal hearing. It looked like they were shielding her and themselves from further scrutiny.
Did Ward maintain she had no ongoing role?
Initially, Ward suggested Curry had no ongoing role after the children's court decision. But again, under Howen's persistent cross-examination, Ward had to backtrack. He admitted she did have some ongoing involvement, like preparing that ministerial brief. Howen felt this concession proved that DOCS's earlier suggestion was misleading, essentially untrue.
Okay, so let's put all these pieces together from Howen's perspective. You've got Ward's angry reaction at the mediation defending Curry. You've got Magistrate Syme's devastating judgment criticizing Curry and DOCS. You've got Ward downplaying those criticisms in the appeal. You've got Curry writing a briefing note that hides the criticisms. You've got DOCS deciding not to call Curry, and Ward backtracking on her level of involvement.
Exactly. For Howen, all these threads weave together into a powerful conclusion. The DOCS's appeal wasn't just about protecting Victoria. He became convinced it had a significant, perhaps even predominant, collateral purpose. Meaning a purpose other than the stated legal one. His theory, as it crystallized, was that DOCS and its officers, particularly Ward protecting Curry, were appealing primarily to salvage their damaged reputations after Magistrate Syme's judgment. They were using public funds in the court process not just for child welfare, but for self-preservation and face-saving. This is the very serious allegation of abusive process.
Using the court for an improper motive. And for a barrister to make that kind of allegation in court, that's incredibly serious, isn't it?
It is extremely serious. It's right up there with alleging bad faith or even fraud on the court. And this brings us smack bang into the fundamental ethical tension every barrister faces.
Which is?
You have an absolute duty to be a fearless advocate for your client. You have to put their case forward strongly, test the other side's case rigorously. But, and this is the crucial but, that fearlessness isn't a license to just say anything you want. You absolutely cannot make serious allegations of misconduct against someone, whether it's fraud, dishonesty, abusive process, without having a proper basis for it in the evidence available to you.
There has to be some factual foundation. You can't just make things up or throw mud hoping it sticks.
Precisely. And the foundational case in Australian law on this is Klein v. NSW Bar Association, a high court decision from way back in 1960.
What happened in Klein?
In Klein, a barrister was actually struck off the roll. Why? Because he used the absolute privilege he enjoyed in court, meaning he couldn't be sued for defamation for what he said in court, to make absolutely scandalous, completely unsubstantiated personal attacks against the solicitor on the other side. It seemed pretty clear he was just trying to intimidate the guy.
And the High Court said that's not on.
Exactly. They said, yes, barristers have privilege, but they must not abuse it. You cannot accuse someone of evil conduct or make statements with potentially ruinous consequences for their reputation unless you have reliable information to warrant the suggestion. You can't just fire off accusations based on suspicion or thinking you might be able to drag some proof out of a witness during cross-examination. You need a real, solid, factual foundation before you make the allegation.
And these principles were codified in the barrister's rules at the time Howen was practicing.
Yes, they were. The rules reflected Klein. For example, Rule 35 said that any allegation made under privilege must be A. Reasonably justified by the material available to the barrister, B. Appropriate for the robust advancement of the client's case on its merits, C. Not made principally to harass or embarrass someone, and D. Not made to gain some collateral advantage outside the actual court case.
Pretty clear guidelines.
And Rule 37 was even more specific about serious allegations. It stated that a barrister must not allege criminality, fraud, or other serious misconduct, unless the barrister believes, on reasonable grounds, that two conditions are met. First, the available material provides a proper basis for the allegation, and second, the client wishes the allegation to be made after being advised of the seriousness and potential consequences.
So it's this constant balancing act. Be fearless for your client, but only speak with a solid foundation of evidence and with your client's informed instruction if you're alleging serious stuff.
That's the tightrope. And this tension absolutely explodes in the courtroom on October 15th, 2002. It's the 10th day of the district court appeal hearing. Howen is cross-examining Mr. Barry Ward, the DOCS director. He's been building his case piece by piece based on the points we discussed. And now he goes there directly. He makes the allegations.
And the sources give us the exact words from the court transcript. These sound pretty dramatic.
They are. Howen says to Ward something along the lines of, "The evidence so far suggests, or in fact explicitly reveals, that Miss Curry has had an ongoing role, that Mr. Ward is not correct when he says that she has no ongoing role. It is obvious. Mrs. Curry is involved in this up to her neck, and Mr. Curry is an active and ongoing participant in this matter." And then he says it is a lie for the department to suggest that she has no ongoing role.
Wow. Calling a statement by a government department in evidence a lie. In open court. That is incredibly strong language.
It is. And he doesn't stop there. He continues. Notwithstanding Deputy Chief Magistrate Syme's direction that Miss Curry have no further contact, she continued to pull the strings behind the scenes. The evidence shows that quite clearly. And then this. So Miss Curry and the department have shown complete contempt, I submit, for not only Deputy Chief Magistrate Syme's judgment, but complete contempt. The fact that they won't bring her here and the fact that Mrs. Curry is being hidden in this matter.
So now he's accusing DOCS and Curry of contempt for the previous court's decision and accusing DOCS of actively hiding Curry as a witness. The gloves are well and truly off.
Completely off. And he follows up with direct questions drilling down on the department's alleged improper motive. "This is about protecting a mate, isn't it?" he asked Ward, referring to Curry. And then, even more explicitly, "This is about using the unlimited resources of public funds to win at all costs for the purposes of simply rescuing the tarnished reputation of an officer. Isn't that right?" He is now explicitly alleging that the appeal's primary driver is a collateral one protecting reputation, not the child's welfare. Abusive process.
Okay, the barrister for DOCS, Mr. Burke, he must have objected immediately.
He did. He jumps up, objects strongly, calls it lightly throwing forward an incredibly serious abusive process allegation, saying it's tantamount to alleging fraud. He specifically invokes the Klein principle. You need a proper basis for accusations like this.
And the judge, Judge Hogan, what does he do?
Judge Hogan, clearly recognizing the gravity of the situation, stops the proceedings right there. He turns directly to Howen and asks the absolutely crucial question, referencing the ethical rules Howen is bound by. He says something like, "All I can do is to ask Mr. Howen whether he has instructions within the relevant advocacy rules for making such an allegation. Do you have a proper basis? Do you have instructions that enable you to make that allegation within the terms of the advocacy rules?"
This is the pivotal moment, isn't it? The judge is putting Howen on the spot. Do you, as an officer of the court, assert that you have the necessary evidence and client instruction required by the bar rules to make these potentially career-damaging, reputation-ruining accusations?
Precisely. It's a direct challenge to Howen's professional integrity. And Howen's response is completely unambiguous. He replies, "Yes, Your Honor. I understand my obligations. Yes, I do." He affirms it twice. He states unequivocally that he believes he does meet the ethical standard required by the rules to make those statements.
He puts his professional standing on the line right there, and Judge Hogan's response to that affirmation.
Judge Hogan says simply, "Then I can't stop you. Carry on." He had done his duty by asking the question. Howen had given his assurance on his professional honor that he had the proper basis in the client instructions. So the cross-examination and the trial continued.
What was the eventual outcome of that district court appeal? Did Mrs. X keep custody?
It's a bit complicated, but the final result was that Judge Hogan did find the grounds for a care order established, differing from Magistrate Syme. However, he ultimately endorsed a permanency plan that involved restoring Victoria to Mrs. X's care under strict conditions, which eventually happened in May 2003. So Mrs. X did ultimately retain custody. But for our story, the focus isn't the custody outcome itself, but Howen's conduct during that appeal hearing.
And immediately after that confrontation in court, Judge Hogan didn't take any action against Howen? No contempt charge, no referral for misconduct?
No, not at that point. Judge Hogan didn't cite him for contempt or make any immediate referral. Howen had pushed incredibly hard, he'd made his points very forcefully, and he directly addressed the judge's ethical query. He seemed to have navigated that immediate judicial scrutiny. And as we mentioned earlier, he likely felt some justification when Ward later conceded. Corey did have some ongoing role, which Howen would have seen as supporting his submission that DOCS's initial denial was effectively untrue or lie in the context of his argument.
But those dramatic accusations, lying, contempt, abuse of process, made publicly against a government department and its senior officers, they couldn't just be ignored indefinitely.
Absolutely not. You can imagine the reaction within DOCS. Mr. Ward, Ms. Corey, others involved. They would likely have been furious at being publicly accused of such serious misconduct. The fuse was lit for disciplinary action. And indeed, sometime after the district court case concluded, the tribunal judgment indicates the complaint was made by May 8th, 2003. A formal complaint was lodged with the NSW Bar Association.
Who made the complaint?
According to the tribunal judgment, the complainant was Mr. Roderick Best, who was the Director of Legal Services at DOCS at the time.
So the complaint goes to the Bar Association, the governing body for barristers and NSW. What happens then?
The Bar Association's Internal Professional Conduct Committee investigates the complaint. They would have reviewed the district court transcript, considered the context, perhaps interviewed relevant parties. This investigation took some time, but eventually they concluded there was a case for Howen to answer regarding potential professional misconduct. On December 1st, 2005, the Bar Council formally resolved to refer the matter for external adjudication.
Where do they refer it?
To the Administrative Decisions Tribunal, the ADT, specifically its Legal Services Division, which handled disciplinary matters against lawyers. The formal application setting out the charges against Howen was filed with the ADT on January 17, 2006.
And this sets the stage for the next major chapter, the tribunal hearing where Howen's own professional conduct, his ethics, were put on trial.
Exactly. This is Section 4, the Tribunal Ethics on Trial. The hearing itself took place over 3 days in early 2007, February 12th and 13th, and then resuming on May 21st. It was held at the ADT premises in Sydney.
And Howen is now the respondent, defending his actions.
Yes. He's represented by his own senior counsel, Mr. Martin Williams, SC, and junior counsel, Nicholas Murray.
And prosecuting the case, arguing that Howen did commit misconduct.
That was the counsel of the NSW Bar Association, represented by another senior counsel, Mr. Anthony Mahoney, SC, assisted by Simon Pritchard. So you have this intense situation. Senior barrister versus senior barrister, debating the ethical boundaries of advocacy, with another barrister's career hanging in the balance.
Who made up the tribunal panel deciding the case?
This is a 3-member panel comprising experienced legal figures. Deputy President R.M. Chesterman, ADCJ, a judge acting as deputy president, judicial member Lori Roberts, QC, another senior barrister, and a non-judicial member, R. Fitzgerald. Their job was to hear the evidence, consider the arguments, and determine if Howen's conduct fell short of the standard expected of a competent and honorable barrister. Did it amount to professional misconduct?
What were the specific charges, the grounds of complaint against Howen?
They focused directly on those statements he made back in the district court appeal in October and November 2002. The absolute core allegation was that Howen had alleged serious misconduct, abuse of process, acting for collateral reasons, lying, contempt against DOCS and Mr. Ward, without believing on reasonable grounds that the material available to him at the time actually provided a proper basis for making such grave allegations.
So it wasn't just about using strong language, it was about whether he had the factual foundation required by the rules.
Precisely. Ground one of the complaint targeted the allegations against DOCS as an entity, accusing them of pursuing the appeal as an abusive process for collateral purposes, protecting reputation, showing contempt for Magistrate Syme's judgment, and lying about Mrs. Corey's ongoing role.
And ground two.
Ground two mirrored that, but focused on the allegations made against Mr. Barry Ward personally, accusing him of authorizing the appeal as an abusive process for collateral purposes, showing contempt for the magistrate's decision, and lying about Mrs. Corey's role.
So the Bar Association's core argument was essentially that Howen fundamentally breached the Klein principle and the spirit of the barrister's rules like 35 and 37. He made the serious allegations without having the required reasonable grounds based on available material.
That's exactly it. They weren't formally charging him with breaching specific rules, but arguing his conduct overall constituted professional misconduct under the Legal Profession Act. The benchmark they used was the classic Allenson test. Was his conduct such that it would be reasonably regarded as disgraceful or dishonorable by his professional peers, competent, reputable barristers? And those rules about needing a proper basis obviously informed what that standard meant in this context.
How did Mr. Marnie SC for the Bar Association build that case against Howen at the tribunal?
Monty argued forcefully that Howen's statements weren't just robust advocacy. They were deliberate, extremely serious accusations of misconduct. His central point was that Howen simply lacked the necessary reasonable grounds or sufficient available material at the time he made those statements to justify them. He kept coming back to Klein. You can't make savage attacks. You can't make allegations with ruinous consequences based purely on suspicion or the hope you might dig something up later in cross-examination. He argued Howen didn't possess the reliable information to warrant the suggestion, quoting Klein directly.
Did Marnie suggest Howen had lost his professional detachment?
Yes, he did. He argued Howen might have become too personally involved in the case, losing the necessary objectivity. He cited another disciplinary case, Di Silvero, where a finding of lost objectivity was made against a lawyer. Monty felt Howen's cross-examination of Ward wasn't a legitimate, evidence-based exploration, but rather a vehicle for venting unsubstantiated accusations, perhaps driven by Howen's own feelings or a preformed theory lacking sufficient factual support at the time. He also suggested Howen was somewhat evasive when cross-examined at the tribunal hearing itself, implying Howen hadn't fully accepted the gravity of his conduct, although Monty stopped short of directly challenging Howen's overall credibility as a witness.
Okay, a strong case put by the Bar Association. How did Howen's defense team, led by Mr. Martin Williams, SC, respond? How did they argue his actions were justified?
Williams mounted a very detailed and robust defense. First, he tackled the idea that Howen had immediately launched into unqualified allegations of abusive process. He argued that initially, particularly on October 15th, Howen was merely raising the possibility of a collateral purpose. His questions, Williams argued, were framed to test whether the evidence might lay a foundation for such a submission. Later on, he wasn't asserting it as fact from the get-go. So, probing rather than accusing initially? That was the argument for the early stages. Though Williams did concede that some of the later questions put to Ward did amount to a more direct allegation that a collateral purpose was the predominant motive for the appeal. But the core of the defense was that Howen was absolutely entitled to probe this line of questioning.
Why was he entitled? What was the justification?
Because, the defense argued, Howen did have a reasonable basis, based on the material available to him at that time, to suspect that there was an improper motive behind the appeal. They then systematically laid out all the pieces of evidence Howen was relying on when he made those statements and when he answered Judge Hogan's question.
The list we discussed earlier.
Exactly. Williams went through them point by point for the tribunal. 1. Ward's angry outburst at the 2001 mediation showing personal investment in shielding Corey. 2. Magistrate Syme's incredibly detailed and damning judgment, providing a solid factual basis for DOCS being stung and potentially motivated to salvage reputations. 3. DOCS's immediate attempt to bypass a full appeal via the Supreme Court, suggesting desperation to undo Syme's findings quickly. 4. Ward's defensive and minimizing testimony during the appeal itself regarding Syme's criticisms looking like an attempt to downplay the judgment's impact. 5. The emerging evidence during the appeal that Corey did continue to have involvement, ministerial brief advising others, despite Ward's initial suggestions otherwise making DOCS's position look misleading. 6. The deliberate decision by DOCS not to call Corey as a witness highly suspicious given her central role. 7. And importantly, Mrs. X's own strongly held belief and instructions to Howen that DOCS was motivated by saving face, which, combined with the objective material, formed part of the basis for pursuing that line. Williams argued that taking all this material together, while perhaps not ironclad proof that reputation was the only or even predominant reason for appeal, it absolutely provided reliable information and reasonable grounds for a competent barrister to suspect, to investigate, and yes, even to allege that the appeal was at least partly driven by improper motives. He argued this met the standard required by Klein and the barrister's rules.
So he had enough smoke to justify looking for and even suggesting fire.
That's a good way to put it. The defense argued Howen wasn't firing blanks. He had legitimate ammunition based on the accumulating evidence and circumstances. Williams also stressed the barrister's duty to be fearless. He quoted Klein back at the Bar Association, highlighting the part that says it's not just the right, but the duty of counsel to speak out fearlessly when the occasion demands it. He argued Howen was doing exactly that, robustly pursuing a legitimate line of argument critical to his client's case, backed by the material available. He argued the strong language and allegations, while forceful, were appropriate and reasonably based for advancing Mrs. X's case on its merits.
So, two very different interpretations of the same events and the same ethical rules. How did the tribunal see it?
After hearing all the arguments, reviewing the transcripts and evidence, the tribunal took several months to deliberate. Their comprehensive written decision was finally delivered on September 5, 2007.
And the outcome?
The outcome was a significant victory for Alexander Howen. The Bar Association's application against him was dismissed. He was cleared of professional misconduct regarding his conduct in the district court appeal.
Cleared. Completely. After making those explicit allegations of lying, contempt, and abuse of process.
Completely cleared on those charges, yes. And the tribunal's reasoning is absolutely crucial here because it explains why his conduct, which was undoubtedly aggressive, was ultimately found not to have crossed the line into professional misconduct in this specific instance.
What was their reasoning? How did they justify clearing him?
They meticulously went through the defense arguments and the material Howen relied upon. They concluded that, yes, taking all those pieces together, the mediation incident, Syme's damning judgment, the Supreme Court attempt, Ward's defensive testimony, the evidence of Corey's hidden ongoing role, the decision not to call her, Mrs. X's instructions, this combined material did provide reasonable grounds for a barrister to suspect, and therefore to allege, that the DOCS appeal was driven, at least in part, by a purpose other than purely the child's best interests, namely the protection of DOCS's and Corey's reputations.
So they agreed he had a proper basis.
They found he had a proper basis for the allegation, yes. Applying the Klein standard, they concluded Howen possessed reliable information to warrant the suggestion he was making. They used the analogy he wasn't firing blanks. He had some bullets, some factual basis for his suspicions and allegations, even if it wasn't definitive proof of a predominant collateral purpose. They acknowledged DOCS had legitimate reasons too, but the material pointing towards reputational damage control was strong enough. They noted Ward's testimony showed an apparent incapacity or unwillingness to acknowledge the severity of Magistrate Syme's criticisms of Corey, which lent weight to Howen's suspicion.
What about the specific words calling DOCS's statement a lie and accusing them of contempt? How did the tribunal deal with those?
They interpreted the lie statement in context. They didn't see it as Howen just randomly accusing DOCS of general dishonesty. They saw it as his forceful submission, based on the evidence emerging, like Ward's backtracking on Corey's role, that DOCS's apparent claim of no ongoing role for Corey was factually untrue. They found Howen was on solid ground making that submission, as Ward's own concessions ultimately supported it.
And the contempt accusation?
The tribunal likely viewed contempt as strong language, maybe even hyperbolic, but again, not plucked out of thin air. It was grounded in the documented facts. DOCS did keep Corey involved behind the scenes despite Magistrate Syme's implicit direction, and they did appeal a judgment that fiercely criticized her. Howen was arguing this showed a disregard for the spirit of Syme's decision. The tribunal seemed to view it as an inferential leap Howen was entitled to argue for, based on the evidence, not an unfounded smear, as they put it.
So, the core finding was, because Howen had this proper basis rooted in the available material, his aggressive advocacy, even using very strong language and making serious allegations, did not cross the line into professional misconduct in this particular case.
Precisely. The tribunal essentially reaffirmed the principle from Klein that barristers can, and sometimes must, vigorously attack the conduct of parties or witnesses if they have justification in the evidence. Howen's conduct, in their carefully considered view, fell into this category of permissible, albeit very forceful, advocacy. They also specifically rejected the Bar Association's suggestion that Howen had lost objectivity like the lawyer in the DeSevero case, finding no evidence he'd become too personally involved to the point of losing reasonable grounds for his beliefs.
So the complaint was dismissed. Howen was vindicated on this matter.
Yes. The tribunal's formal order was simply that the Bar Association's application was dismissed. The issue of legal costs was left to be decided later. Although Howen apparently preferred privacy initially, the decision was published, using pseudonyms for the family involved. And Counsel of NSW Bar v. Howen, 2007, and SWAT 200 became quite a notable reference point in legal ethics discussions.
Why was it significant? What did it highlight?
It highlighted that aggressive advocacy isn't automatically misconduct. Context matters. Good faith matters. If you genuinely believe, based on reasonable grounds arising from the material, that you need to make strong allegations to advance your client's case, you might have leeway. It showed the importance of that proper basis. But it didn't change the rule about baseless attacks. Those, like in Klein, remained clear professional misconduct. It just affirmed the space for vigorous, evidence-based advocacy.
So Alexander Howen, after staring down the potential end of his career because of his courtroom tactics in the DOCS case, walks away cleared by the tribunal. He can continue practicing as a barrister.
He could, and he did. He had faced a significant ethical challenge regarding the limits of advocacy, and, according to the tribunal, had stayed just inside the line. He returned to practice, presumably with a heightened awareness of those ethical boundaries.
However, the story doesn't quite end there, does it? The sources indicate this wasn't the last time Alexander Howen faced disciplinary action.
No, tragically for him, it wasn't. A separate, completely unrelated complaint was already making its way through the system around the same time or shortly after.
And this next complaint wasn't about aggressive advocacy or pushing boundaries in court.
No, this was something entirely different. It concerned Howen's handling of a case for a client named Michael Iverson, who was pursuing an unfair dismissal claim against his former employer, Qantas.
And this separate matter led to a second finding of professional misconduct against Howen.
It did. In May 2008, news broke that Howen had indeed been found guilty of professional misconduct in relation to the Iverson case. And the core allegation this time was starkly simple and arguably much more clear-cut.
What was the allegation?
He had deliberately misled the Australian Industrial Relations Commission, essentially. He had lied to the court.
Lied about what?
He lied to cover up his own failure, his own significant delay, in filing Mr. Iverson's unfair dismissal application on time.
How did he mislead the commission? What excuse did he give for the delay?
When the commission questioned the lateness of the filing, Howen told them that the reason for the delay was that his client, Mr. Iverson, had been suffering from months-long depression, implying that the client's mental health struggles were why the paperwork wasn't lodged sooner.
But that wasn't true.
It was completely untrue, according to the findings of the Bar Association's investigation, which were ultimately accepted by the Disciplinary Tribunal. The truth was the delay was entirely Howen's own fault. Mr. Iverson had actually been chasing Howen for over 4 months, urging him repeatedly to file the case. Howen had simply procrastinated, failed to act diligently. When the delay became an issue before the commission, instead of admitting his own failure, Howen fabricated an excuse, blaming his own client's mental health to mislead the judicial body.
So this wasn't about interpreting evidence or drawing inferences. This was a straightforward case of dishonesty, lying to the court to save his own skin.
Exactly, a fundamental breach of the duty of candor. That absolute requirement for lawyers to be truthful, honest, and frank with the court. It's often described as the bedrock ethical duty, overriding almost everything else, including, in many situations, the duty to the client.
And what was the ultimate consequence for Howen for this finding of misconduct for misleading the court in the Iverson case?
The consequences this time were swift, severe, and final. Based squarely on this finding of deliberately misleading the court, the NSW Bar Association applied to have Alexander Howen struck off the roll of barristers. And in September 2008, the Administrative Decisions Tribunal agreed with the Bar Association. Alexander Stanislaw Howen was removed from the role. He was struck off. His career as a barrister was over.
Wow. So the barrister who survived even won a disciplinary case based on incredibly aggressive advocacy and accusations of lying and contempt against a government department. Was ultimately struck off for what sounds like a relatively simple, albeit serious, lie to the court in a completely different case.
That is the stark, unavoidable, and absolutely crucial distinction that makes the whole Howen saga such a powerful and, frankly, sobering cautionary tale. It's all about the nature of the conduct.
Can you unpack that distinction? Why was one survivable and the other career-ending?
In the first case, the 2007 tribunal decision concerning the DOCS appeal, Howen was aggressive, yes. He made extremely serious allegations. He used very strong language. But the tribunal, after deep analysis, found that he acted, or at least they couldn't be satisfied he didn't act, with what they deemed a reasonable basis in the complex contested material available to him. He was seen as pursuing his client's legitimate interests, albeit at the very edge of permissible advocacy. The tribunal found he hadn't crossed the ethical line in that specific, complex instance.
Okay, that was about the limits of advocacy based on inference from evidence. But the Iverson case.
The Iverson case was fundamentally, radically different. That wasn't about interpreting ambiguous evidence or pushing the boundaries of inference. That was about fabrication. It was about putting forward a statement blaming his client's mental health that Howen knew to be false, purely to protect himself from the consequences of his own professional negligence. It was plain and simple professional dishonesty, lying to the court.
And that distinction provides critical lessons, doesn't it? Especially for anyone thinking about a career at the bar or practicing law generally.
Absolutely. It crystallizes some fundamental truths about legal ethics.
Know the lines of aggressive advocacy. The first case, the DOCS case, shows that vigorous, even confrontational advocacy isn't inherently wrong. Sometimes it's necessary, especially when challenging powerful opponents. And it's huge, but it must always be grounded in that proper basis. You need reliable information, reasonable grounds drawn from the available material before you make serious allegations. You can use strong words, allege bad faith, even lying or contempt, if and only if you have solid grounds to back it up. The 2007 Howen decision is a key reference point for understanding how incredibly fine that line is and how context and the available evidence are scrutinized. Step over that line without the evidence, and you risk the fate seen in clients striking off.
So advocacy has limits, but they require a factual anchor. But the second case, the Iverson matter, delivers perhaps the most critical lesson of all.
Unequivocally. Lesson 2. The duty of candor to the court is paramount and absolute. The Iverson case, and Howen's subsequent striking off, hammers home what is arguably the most fundamental, non-negotiable rule of legal practice. You must never mislead the court. Full stop. Honesty, frankness, candor, this duty to the administration of justice is sacred. It overrides your duty to your client's immediate interests. It overrides your desire to avoid embarrassment. It overrides everything. Howen's deliberate lie in the Iverson case, concocted simply to hide his own delay, was seen as a grievous sin by the profession. His story is the starkest possible reminder that one single act of calculated dishonesty to the court can destroy a career, no matter how skilled or successful you might otherwise be.
It's such a powerful contrast. He was cleared for being perhaps the fiercest possible advocate, pushing right to the edge based on his interpretation of evidence, but then struck off for telling a straightforward lie when the evidence pointed clearly to his own failure.
Exactly. And that contrast highlights the clear hierarchy of ethical duties for a barrister. Fearless advocacy, hugely important. Duty to the client, critical. But both are secondary to the paramount duty of honesty and candor owed to the court and the administration of justice. And maybe there's a lesson 3. The system ultimately can distinguish. The fact that the Bar Association pursued both complaints and that the disciplinary tribunals reached different outcomes based on the fundamentally different nature of the misconduct in each case shows that the disciplinary system is capable of making these difficult distinctions. It can differentiate between robust, evidence-based advocacy that pushes boundaries even if uncomfortably, and outright dishonesty designed to deceive. Howen was cleared in 2007 because the tribunal found he hadn't crossed the line based on the evidence presented about that specific conduct. He was struck off in 2008 because he undeniably had crossed the bright line of fundamental honesty.
It really is like that high-wire act analogy you mentioned earlier. You need the balance, fearlessness, and advocacy on one side, absolute fidelity to truth and candor on the other.
It is. And Howen, according to the tribunal's assessment in 2007, successfully walked the fearless advocacy wire in the DOCS case, navigating incredibly complex evidence, inferences, and high emotions. But he fell completely and irrevocably on the fidelity to truth wire in the Iverson case.
Just briefly, what happened to the others involved in that original underlying child protection case?
Well, based on the timeline in the sources, Victoria, the little girl at the center of it all, would be in her mid-20s now. We can only hope that she has had a safe and healthy life since those traumatic early years. Mrs. X, her mother, as we discussed, did ultimately regain custody following the district court appeal outcome in May 2003, although we don't know what might have happened subsequently. As for DOCS and the officers involved, like Mr. Ward and Miss Corey, they presumably continued their careers, but likely carried with them the profound experience of having their professional conduct intensely scrutinized on the public record. And Magistrate Syme's original detailed judgment remains a notable example in discussions about judicial oversight of child welfare agencies.
But it's Alexander Howen's name and his story that really lives on in legal ethics discussions as this cautionary tale.
It really does. His story is a vivid, modern-day illustration of the principles laid down decades ago in Klein. It teaches aspiring and practicing barristers not only about the critical importance of having a proper evidence-based foundation before launching serious allegations, but perhaps even more forcefully, it underscores the absolute unforgiving consequences of failing in that most fundamental duty of all, the duty of candor to the court. The evidence didn't lie in the Iverson case, but Howen did, and ultimately that was his undoing.
Which leaves us, perhaps, with a significant question to mull over. Given the whole trajectory of the Howen case, particularly the stark difference between the outcomes of the two misconduct findings, one cleared, one struck off, what does this really tell us about the hierarchy of ethical duties for a barrister? Is that duty of candor, of honesty to the court, truly the most sacred, the one obligation that stands paramount above all others, even above the duty to fight tooth and nail for your client's immediate desires, or even protecting your own professional reputation?
It certainly seems that the answer from the legal profession, starkly underlined by Alexander Howen's ultimate fate, is a resounding yes. And figuring out exactly where that incredibly fine line lies, moment by moment under pressure, in the heat of a contentious case, well, that remains the constant, demanding, and absolutely critical challenge faced by every single lawyer who steps into a courtroom.
That was the complex, dramatic, and ultimately cautionary story of Alexander Howen. A story that began with a child in grave danger and ended with a barrister's career, lost not for the spectacular courtroom fireworks many might have initially assumed, but for a fundamental failure in basic honesty. It's a powerful illustration that the essential skills of fearless advocacy must always be built upon the non-negotiable bedrock of truthfulness to the court. Thank you for joining us on this deep dive into the Howen case. We hope exploring this real-life legal drama with all its complexities and ethical dilemmas has provided some valuable insight into the intense world inhabited by those who navigate the justice system.